Hello viewers, welcome to our program on immigration and public affairs. Legal affairs now. And today we have again with us Attorney David Nachman and Mr.
Hi.
Mitchell Ignatoff. Remember in the last program, Mr. Ignatoff told us and all our viewers about the consequences of crimes on immigration. And many of you probably would have experienced yourself, or maybe friends or maybe relatives who went into these problems because some small thing happened. Maybe a shoplifting, maybe selling a can of beer to a minor, or a pack of cigarettes to a minor, or maybe a charges of sexual abuse, which every client denies, I never did that, she is complaining. But end of the day, what happens frequently, we discuss about that, and again I think want to go back to this issue, very, very important, that some of the criminal lawyers who are not very experienced, they are only looking at disposition of that particular case. And they say, listen, this case you have to fight, it may cost you a lot of money and time, what's a big deal? Well, the judge is going to ask me, say, okay, plead guilty and pay $500, $200 fine, and you are back home. Say, oh sir, wow, such a great lawyer, excellent. Just I'll pay $500,000, don't worry, just get me out. And they plead guilty. Now, pleading guilty puts him there in a big problem, and I'm going to have Mitch talk about that bad practice, first of all, on the part of criminal lawyers who do that. And again, in the Padilla case that we talked last time, it is now mandatory on the part of criminal lawyers to advise the client that, okay, but if you do that, there's a consequence of immigration, right?
That's correct.
Your turn.
Yes, you have to advise, under Padilla versus Kentucky, every criminal defense lawyer has to advise the client of the immigration consequences of their plea.
Or would you say to the client that it's a good idea for you or for me to consult an immigration attorney to discuss with him
Of
that
course.
this is the crime and what happens if we plead guilty or plead not guilty or plead guilty for a lower crime? And I think once you had mentioned earlier, probably in the program, that some people can plead for a lower offense, which may not be a big problem. For example, a shoplifting.
You can plead that
It's
to
a
what's
big
called a
crime.
disorderly.
But then you can just cut it down to, bring that down to, water down to just disorderly conduct, which is really not a big problem.
Correct.
So it's very, very important, isn't it?
Yes, it's very important because obviously, you know, you need a criminal defense attorney who knows something about this area and has enough sense to pick up the phone when he doesn't know something about this area and call an experienced immigration attorney and ask them, what's the consequence if we do this or we do that? And then you can make a decision as to which way you want to go, whether you have to go to trial, whether you can work out some kind of plea agreement to some kind of lesser or other offense.
So let me ask you this question, two-pronged question is this. Let us say one of our clients, one of our viewers, or one of our viewers' relative friends went in and plead guilty because they are wrongly advised by the criminal lawyer. They are not advised by the criminal lawyer, not warned about the Padilla case. What are the options? And I want you to talk about, on that basis alone, can a motion or application be made to reopen the case and have a rehearing? And the other thing, of course, you can also talk later on, assuming that it sticks, it cannot be opened, he's stuck with it. Then what is the post-conviction relief? For example, nothing we can do to change. No, it is there. That Padilla case doesn't help, for example, and a person is now stuck with the immigration problem because he had advanced sexual abuse or whatever happened. Can you go back to the court and tell them to reopen the case and change the sentence?
And I'm sorry, if I can just interject here. I think, Michael, you're getting into an issue of what's called retroactivity of Padilla, and that, as Mitchell will explain, is something that's sort of up in the air. But go ahead, Mitchell.
Yeah, let me start there. It is up in the air. I think if you read Padilla, what the Supreme Court said was that under what's called the ABA standards, which is supposed to guide all lawyers across the country, the ABA has held for the last 15 years or so that criminal lawyers are supposed to advise their clients of the immigration consequences of their plea. If they don't do that, or if they haven't done that and you've pled guilty or you've been found guilty, then you have at least this beginning point of asking the court to vacate the conviction, go back and reopen the case, and perhaps even retry the case.
So it's an opportunity for viewers who have pled guilty without knowing what the immigration consequences are to go back.
That's correct.
That means that then they can go back and plead guilty for some lower.
Perhaps. What it does, after you show that you weren't properly advised of the immigration consequences. After that, you then have to show that there was some kind of prejudice, which basically means that you would have gone to trial if you had known what the immigration consequences were, because the immigration consequences may be deportation rather than just jail or loss of license or something. Once you've gone through both of those prongs, then you get to perhaps retry the case. Often what happens is, because it's such a long period of time, or because you've in fact bettered yourself, the prosecutor is very often willing to accept, in New Jersey, an application for PTI, perhaps downgrade the charges, or perhaps even dismiss them if you've really made an effort to better yourself. I mean, I've had this happen. I've reopened the conviction from 1987. Client came in, he got involved in a little drug crime, he was convicted. Law comes forward to today, all of a sudden immigration wants to deport him. But since that time, he's worked steadily, he's married, he has a family, he's paid his taxes, and he hasn't been any trouble to the law. He hasn't gotten in any trouble at all. When we reopened that case, I was able to convince the prosecutor to at least let him be in what's called pretrial intervention in New Jersey. And when he completes pretrial intervention, his criminal record will be gone. He won't have any. And then he has no immigration consequences from that stupid thing that he did.
So it's a form of underlying recognition of rehabilitation.
That's correct.
And which is a public policy in criminal law, which is sort of recognized as an equity, if you will.
That's correct.
So the piece of advice is that if a person has been convicted of a crime, just don't accept and sleep over it. There's always an opportunity, possible solutions to that. We can go talk more about that. I think it's just time for a short break. And right after the break, we are going to come back, and Mr. Ignatov is going to tell you many, many more interesting things like a post-conviction relief, etc., etc. Stay tuned. We will be back. Welcome back. And just before the break, we were talking about the consequences of crimes on immigration, and our chief guest here, Mr. Michel Ignatov, was telling you many situations, many type of crimes and how they are handled, what can be done, what cannot be done. And before I ask you any questions, I just wanted to tell our viewers that Michel Ignatov is an attorney who practices criminal defense law in the state of New Jersey, New York, and Pennsylvania, so he's familiar with at least all these three states. Of course, there are general laws, but I believe that federal crimes are federal.
Correct.
They are all over the country, they are the same.
That's correct.
But state laws may vary from state to state, and whenever we discuss about these issues, first thing we have to see what is the crime in a particular state, in the state. Person is coming from Pennsylvania to you, Philadelphia, and you want to go first, oh, what is the Philadelphia law says. So that is also very, very important thing for people to understand. Now, let me go back to this question. Earlier to the break, we were talking about reopening of cases because the criminal attorney did not advise the client about the consequences on immigration. And I'm going to go back to another question that, as I said earlier, that nothing we can do on that, that crime is stuck. Our client is now under a big problem with immigration.
Correct.
The question here is that, is there something called a post-conviction relief? Let me, if you don't mind, say in Hindi, कि किसी शख्स ने क्राइम किया, उसको बदल नहीं सकते, कुछ कर नहीं सकते, उसके वजह से बड़ा प्रॉब्लम है, पर्सन का डिपोर्टेशन होता है, ग्रीन कार्ड होल्डर तो ग्रीन कार्ड चला जाएगा। तो एक ऐसा भी प्रोसीजर है कि जज के पास जाके उस पनिशमेंट को चेंज कराया जाए, मींस इंस्टेड ऑफ लेट्स से सेक्सुअल एडवांसमेंट, डिसऑर्डरली कंडक्ट जो एक छोटी सी चीज़ होती है, ऐसा भी हो सकता है। दैट कैन ऑल्सो बी पॉसिबल, दैट आई एम सेइंग, that a person can go back to the same court and request them to reopen the case and change the conviction. What we call is a post-conviction relief.
Okay, I touched upon that with the case of Padilla, but there can be other bases for post-conviction relief. First, generally you have to show some kind of ineffective assistance of counsel, of criminal counsel, and you can look at, you get the transcripts, you get the discovery. If there's some kind of denial of justice, which can be a whole various nature of grounds, then even if you're not in a Padilla situation, you can still vacate, ask the judge to vacate the conviction because there is something wrong with the basis for the conviction. For instance, in New Jersey, you have to enter a plea by your own voice. The client has to get up there and say, yes, I did it. You have to be properly advised of the general consequences of what your plea of guilty would be. Sometimes people aren't. And you have to be advised of the right to appeal. For municipal court conviction, that's 20 days. For Superior Court, it's 45 days. If you're not advised of any of those things, that entitles you to reopen the conviction. And there, hopefully, because time has passed, because you've improved yourself, hopefully, we can ask a judge and the prosecutor perhaps to either downgrade the charges, to put you in what's called PTI, or perhaps even dismiss the charges. And so post-conviction relief isn't limited to Padilla, those kinds of situations where you haven't been advised of the immigration consequences of your plea, but Padilla is probably the one that jumps out because New Jersey attorneys haven't done it.
I just have a quick question on your personal experience. Can you give us one or two examples of cases where you are able to go and get a post-conviction relief? You must have done a lot of time, but some interesting.
I had another gentleman. He was he came from Central America. He worked on a farm. His employer liked him very, very much, and he got you can't get a license. And let me back up. He's illegal. He couldn't get a driver's license. He got into an accident one day, and because of various things, he got convicted of a whole bunch of felonies, all third-degree felonies. That went away. And then he continued working. His employer wanted him to stay because he's a very good farm worker and able to take care of horses. We filed a petition for post-conviction relief because it was clear that his attorney knew that he was an illegal immigrant, but never told him anything about the possibility of being deported as a result of the conviction. We were successful on the petition, not just because he hadn't been advised of the immigration consequences of his plea, but it turned out that in the plea bargain itself, he had not been properly advised of the consequences. So the judge vacated the conviction after discussions with the prosecutor because his employer wanted him here. He'd been a good worker. He'd been paid his taxes. His two children, he had married his two children. They were U.S. citizens. The prosecutor was willing to admit the defendant to pretrial intervention. And so he is still here. He can now naturalize or pursue a green card and take care of his family like he should be.
Mitch, you just said something like a felony.
Correct.
And there are two types of crime, felony and a misdemeanor.
That is correct.
So felony is much harsher.
Correct.
Then the misdemeanor, viewers probably do not understand.
Okay.
Can you explain what you mean by felony?
A felony is any crime punishable by more than a year and a day in jail. That's the common law definition. That's generally the definition that the federal courts go by. There are, in New Jersey, there's 4 degrees of felony, and then there's disorderly persons and petty disorderly persons offenses and traffic offenses. In New York, it's a little different. There are, I think, 5 degrees of felonies and 5 degrees of misdemeanors, and then there are violations and then traffic offenses. So New York has a more complicated sentencing scheme. But the important part, probably that distinguishes New York and New Jersey, is that a lot of what they call misdemeanors in New York are in fact punishable by more than a year and a day in prison. So under immigration law, they would be considered felonies, serious crimes that can get you deported.
Same thing about, I think David can say about the immigration law, that sometimes one misdemeanor is not a big problem, but 2 misdemeanors become
become problematic for certain people, right?
And I know our viewers know about, I don't want to mention the name of one of the top film actors, because I represent some of the actors. So without making reference to any name, he was a very good actor, big name. And while shooting in a city, he killed 2 black deers, and black deers are religious there. So he had 2 or 3 cases going on for killing a black deer, were misdemeanors. So when the first conviction came in and he applied for a visa, they gave him a visa, no problem at all. But before he traveled to US, the court came with a second conviction on this other deer and became a second misdemeanor. So when that happened, the American consul called him in the consulate and took the passport and canceled the visa, because now he says becomes ineligible because of 2 misdemeanors. So that was an interesting experience. Of course, we were able to get a waiver, because waiver is something that's another big subject that we can talk probably in the next full program we can do next time, about different kind of crimes, different kind of excluabilities, ineligibilities, and what kind of waivers, waiver bolo to maafi nama jaise bolte hain. For example, forgiveness. You call it a waiver with a forgiveness. You are requesting the immigration service to forgive you for that thing that you did and let him get the visa. That is a waiver.
Exactly, and there are waivers, Michael, that are associated with non-immigrant visas. So an individual can get a waiver under 212H or 212D, and then you also have waivers that are associated with green cards, and that's a different waiver process.
Stay tuned, we will be back. Welcome back. Just before the break, we were discussing, we have David Nachman here today and Mitchell Ignatoff, who is a criminal defense lawyer, and a lot of